What's up, y'all? I'm a spontaneous individual. I've been out of here. I said, let me just go ahead and start my video. Let's roll with it. Hold on 1 second. Gotta get my lighting correct. How y'all doing? Since the New Year's end, it's been kind of crazy, hectic. It looks like the courts are going back to in-person appearances. I want you guys to pay attention to that. A lot of you all have criminal and civil cases. You all have been able to appear via Zoom. At least here in Texas, you have been able to. And it looks like the courts are starting to move back to in-person appearances. I repeat, in-person appearances. So if you're out of the state and you've been resetting your case via Zoom, start looking and paying attention, because you very well may have to purchase a ticket to fly back and take care of these cases in person. I was just looking at, my schedule a second ago, for the next up and coming months, and I see that they have stuff set for in person on the dockets. So that means if you already have a notice for court and it has said that you are not in person and you're virtual, they're going to allow those things to continue to be virtual, but everything else is going to start to be set in person now. Looks like it's a movement. And it's not just one court doing it out here. It's I'm looking at all the civil courts and all the family courts look like they're on one accord with that. They're trying to move back towards getting in court. So we will see how that goes. All right. I don't have my robe on today. I will not be putting it on today. I will bring the robe back. But we don't have it on today. And I'm going to roll through some things, guys. Y'all know, now this is purely for your, this is entertaining, okay? It's some knowledge dropped in here, but this is for pure entertainment purposes. So I don't want anybody to hang on my every word. Understand that a lot of this stuff is allegedly, okay? It's a lot of allegations spewing around. A lot of the times I'm going based off of what I see and what I read. And I haven't done any investigation into any of, look, I'm trying to get it the right way. I cannot put my sweater the right way. You try to be fancy and then it's too much. Okay? You try to be fancy and then it's too much. Anyways, so a lot of this stuff is allegedly, it's going based off of what you all have told me and what I'm able to see or know at this time. Okay? And whenever I am on a case, I definitely do my research. I get investigators. I'm not able to do that while we're just talking here. Okay? But I will take your questions. I will take your information, and I will bring you to the court of public opinion, and I will rule. And I'm the judge, and I'm the jury, and I'm the lawyer, and I'm the plaintiff, the defendant, the respondent, the applicant, and the petitioner. Okay? So, let's go ahead and start moving along. You all have asked me a few questions. Let's go ahead and get to answering those questions, okay? Without further ado. Get the other. Okay. All right. This is a good one. Okay. Child custody. Can I move away from the geographical area prescribed in my divorce decree? I'm going to rule and say, no, you cannot. But let's go ahead and listen to what this person is saying. Let's just listen. My youngest daughter, who has special needs, turns 18 this summer. Her child support stops then, and her child support stops. Girl, why? I'll be moving to modify that to keep going on. As long as you need a caretaker, or as long as this child is incapacitated in any sort of way and has special needs that are true categorized special needs under the Texas Family Code, you can get that child support for the rest of that child's life. Anyways, I'm going to finish reading. Let me be quiet. My youngest daughter, who has special needs, turns 18 this summer. Her child support stops then. It wouldn't be if it was mine. And the divorce paperwork says the possession agreement stops at that age too. It wouldn't be if it was mine. You're going to take the child and the child support until there is no more child. Anyways, for what it's worth, I still have the ability to bring her back to see him several times a year. He's a good dad, and that's not why I'm moving away. The move will take us 800 miles away. So what is your question? Okay? Because I don't see a question after that. You're saying, can I move away from the geographical area prescribed in my divorce decree? Guys, as long as there is a court order that says you cannot, then you cannot. What the court order normally says is that if the other person moves outside of the geographical restricted area, then you can move outside of the geographical restricted area without the court's permission. If you're attempting to move before the expiration of that court order, you must get the permission of the court unless the other parent has moved beyond the geographical restriction. That's in your order in plain language. And I'm not going to tell you to do anything that goes against the order. I'm going to say this, just in the court of my public opinion. Your child has special needs. If your child has special needs that are going to have you put going into your pocketbook, this child has autism severely or something along those lines. This child has to have a caretaker. This child has to wear a diaper, pamper, cannot feed or clothe him or herself. This child is very much behind in learning, has a learning disability that puts that child so many years behind. This child is in life skills classes. These are the type of children that more than likely you need to get child support extended on. A lot of people think that child support only goes until the child is 18, but not if the child is not going to emancipate. If a child cannot emancipate, meaning they can't be on their own and the mom can't send them to live on their own, then they're not going to ever emancipate from child support. All you need to do is go back, get the court to recognize that, get that child coded underneath the court order, and get that child support to continue. Okay? And I would get that visitation order to continue also, unless you don't want the visitation order. One of the things, though, is that I would get that visitation order to continue, because as long as you have to, be saddled with taking care of the child, you as a parent are going to need some relief. And you're not the only person that made this child. This is a beautiful child. This is a special child. But parents, you will need relief if you're taking care of a child full time for that child's entire life. And the reason that I would not drop the child support and custody order, just me personally on my own, is that if the father stopped helping with the child after 18, no longer wanted to help me physically with this child, and was only sending child support, I'd move to have it increase based on the fact that he never exercises possession, and that I'm made to exercise possession all of the time, so that I can go against the guidelines for child support, or try to go against the guidelines for child support and get alternative financial help so that I can get away at some point in time. Not to say I want to be away from my child, but I may need a spa weekend. And people don't understand that when you have a special needs child, you don't get those type of things. You don't get the chance to go anywhere. And I believe that is very important to your mental health, for you to be able to get some relief. And so that's why I would not only continue on the child support order, but I would also continue on the custody arrangement, so that I can have certain days that I know that I will be granted relief. I can go to the spa, or I can go handle some things, for the house, and not have to worry about hurrying up and rushing back because the child's with the caretaker, and the caretaker is only there from 7 to 9 or what have you, if that makes sense. People that have special needs children, you guys understand what I'm saying, because you can never leave that child alone. Either you're going to babysit that child, or you may have an older child that's an adult that can babysit that child. But these children are adults and cannot be left by themselves. It's the same thing. So I would say you're going to hold, or I would personally hold someone to that for the rest of the child's life, because you're held to it for the rest of the child's life. And in addition to that, the child should not be ostracized from either parent because he or she has special needs and it goes beyond 18. So, ma'am, I think that you should continue on for that child's mental health with getting that child to and from the dad. If you're going to move that 800 miles away, first of all, again, I would get the support order extended. I would get the custody order extended. While I was doing that, I would attempt to get that geographical restriction taken away. I would argue that I need that geographical restriction taken away for work or whatever purposes, and then just get it lifted, and then I would be underneath the order until that child, is deceased or somehow may be able to emancipate in some shape, form, or fashion. Most of the time, special needs children never emancipate, so that order goes on for the rest of their lives. But you want to make sure that you do. And you also want to make sure that you do because of insurance purposes. There are many reasons. But people don't realize that with special needs children, you can continue child support of a special needs child beyond 18. And guys, a lot of people need to do it. I've had a few clients that have come to me and we have done it. And we haven't gotten flack from the other side. It's not to say that the person won't try to fight it, but most of the time people have genuine morality about themselves, and they know darn well that child is special needs and will continue to need the assistance of, that their parents. and will never be able to get a job and will never be able to move out. And so most of the time, you don't have the other party fighting you over lifelong child support. They understand they're going to have to pay it. They know that. And you go and you get an agreement and you get it taken care of. But if you have to fight them, they will look horrible in court. And I can't, this is just my public opinion. So I don't want to hear anybody saying, this, she said this or she advised this. This is my opinion. You look like a piece of crap if you go in court fighting a child support order of a special needs child that is truly special needs. That's just what I think. I don't know what you would say in order to fight that. I know some people act as if their child is special needs. The children are not truly special needs, but they do that in order to get money from the other side. You'd be able to prove that with medical records. But those that are truly special needs, I don't see somebody fighting you on it. So, ma'am, I just put my twist on your entire question. It's probably not what you wanted to hear, but hey, if you want to go without getting help, you want to let the child support order extinguish at 18, and you want to move, then move. You move, but wait till the child turns 18, because right now it's not extinguished unless you want to pay the money to get that geographical restriction lifted, or you get the consent of the other parent in writing and filed with the court. Then you need to stay put. But honestly, just from my heart, this is just me. I'm a mommy. Let's see this is my favorite paperweight right here. Okay? I just honestly believe that you do what's in that baby's best interest. And if that means that baby should see that daddy, you know what's right. You need to let that baby see that daddy. Because even when she's an adult, doesn't mean she deserves to be ostracized from her father. Especially if he's been a good dad and whatnot. And you're moving 800 miles away with a special needs child. I just want you to reflect. I'm not saying that you don't get the right to carry on your life and do what you need to do, but I'm saying, think. That's all I'm saying. So do what you got to do, but just keep that baby close. And that baby's interests are number one, okay? And even though she's not a baby, she's a special needs, so she'll always be your baby. So, keep that baby's special interest, your special needs, interests at heart, best interest of the child, okay? That's all I'm going to tell you, okay? Let's move on to another one. This is oh my gosh, let me see. Can a doctor revise my IVF treatment, artificial insemination, when I establish patient? I started the treatment, but made a decision to switch a couple times between first and second choice of a partner due to a difficult personal situation. Now I want the first one, as it was my first choice. Both were tested and are candidates for the procedure. Now the only options the doctor agrees to proceed with is none of them and an unknown donor. He is deciding my destiny and tuning my dream of a baby and any chance of having a family. Can he refuse me in services if I don't agree with his choice for me? Can I sue them as no policy? They just say it is not normal. Okay. Wow. Guys, the Texas Family Code has had to go and make provisions within the Texas Family Code for artificial insemination and children that are products of artificial insemination. We are at a time and age where this is something that is quite common. So as well, what is not common is the fact that she is these two. We will discuss that in a second. Artificial insemination is very common. So I just want you all to understand and know that the law does prescribe what it tells us what to do in instances dealing with artificial insemination. This doctor, ma'am, I believe, and I can't tell you because I'm not the doctor, and I'm not giving you advice. I'm just going on my gut here. I'm just bringing you the court of my public opinion. He doesn't feel comfortable with doing what you want him to do. And there are times when somebody comes into my office and I don't feel comfortable doing what they tell me to do. And they will have to find someone else to do what they tell me to do. Find someone else to do what they're telling me to do because I don't agree with it. And it just doesn't fit in good conscience. See, at the end of the day, doctors, lawyers, we have duties to the medical bar, to the state bar, to the courts. We have a duty. And that doctor took a Hippocratic oath not to do things that are improper with the power and authority they were given. Lawyers do as well. So because of that, we have a huge moral standard that is sitting in front of us. And so our moral standards, we're addressed with moral and legal standards, okay? He's addressed with moral and legal and medical standards, okay? So he just don't feel right. That's why he's telling you. That's why I assume he's telling you like it's not normal. Because, ma'am, you come into a situation where you change your donor not once but twice. So now he has two different samples, right? If you change your donor twice, now he's suggesting that you go with a third person, an unknown donor. And the reason that I believe that is because I believe that the doctor's trying to look out for you. I don't know where you are at mentally, and I don't know if that doctor completely knows where you are mentally, because that's an IVF doctor and not a mental health specialist. Probably could be an IVF doctor with mental with mental illness, background. I don't know, but I doubt if he or she is a psychiatrist and an IVF. I just don't think those two go together, and most people that practice IVF or that specialize in that are not psychiatrists. Okay. So I don't think the doctor knows exactly, but it's so much that it's being said to the doctor where he's like, well, I can't do this. Something ain't right here. I don't think mentally you know what you want to do. And I don't feel comfortable moving forward with either one of these two people, because you changed your mind about this too many times. And you change your mind about something that once I do it, we can't undo it. Because you're going to have me make and create a fetus. And once this fetus gets here, we're going to have a problem if it's not with the father that you want and you change your mind again. Then we have a whole human being that is a byproduct of this that I have created. And I think that's a moral dilemma. And I think that doctor has the right to do that. And that's just, you shouldn't, there are certain things in life that you don't second guess. And that's one of them. And you're showing a lot of uncertainty around it. If I were your doctor, I wouldn't move forward with either one of them either. I wouldn't be able to personally do that with that weighing on my heart, because you're switching and flopping back and forth too much. And so the doctor's probably like, just go get a third person that you don't know, because you have a problem with associating this baby with those people. And that is true, ma'am. And I can tell you, just from an attorney standpoint, when you're dealing with clients that associate the other party with the child, you have a problem with that. Those are always the people that I can't seem to like to represent. The child is separate. The child has nothing to do with the person. And so that's what you are not separating. I can see it in your question to me, and your doctor can see it. You don't know how to draw a separation. If a person has allowed you to get their specimen for use, for something that is that serious, then you change your mind about it, you want to get somebody else, then you change your mind about it, you want to go back with the first person. This is not a game, and this is not a joke. And that's what I think he thinks that you think it is. Like, maybe not that it's a joke, because you understand you're paying for this and it's serious to you, but you're not taking this seriously. You're not addressing this with the proper seriousness. I'm not trying to be rude, but I don't know any other word to use. Proper seriousness. You're not giving this the weight that it should have. Ma'am, this is a child. What are you going to do? Like, you're acting like this is a sale piece at Macy's. If the child does not, you cannot do that, ma'am. That's the problem. Or sir, because you could be a sir. But you're going to be a ma'am. Because if you were trans, you'd go by ma'am. I just have to get my pronouns fixed. Listen, ma'am, no. That's the problem. You're going back and forth, and he's afraid. He or she, that doctor's afraid. If they move forward with the one that you want, you're going to change your mind mid-stroke, and you cannot change your mind. That baby will be made. Okay? And doctors can't go destroying fetuses. They can't do stuff like, I don't think you understand. Then they're going to be stuck with a fetus that needs to be implanted. I don't know, or what he would have to do. But you're not stable, ma'am. You're going back and you're going forth and you're going forth and you're going back and you're over here. You with one, then you want two. Now you want one. Now you mad because he want three. I'll do you too. I'll tell you, take your whole case, all your sperm, and exit. That's what I would do. But I don't know if an IVF specialist can do that. But I think that's pretty much what he's doing. He's telling you to do. So at the end of the day, you have to roll what the doctor says, ma'am. Don't try to sue the man. I'm not going to tell you legally whether or not you can sue him. I'm not going to answer that. I'm going to tell you this. Girl, that man has to sleep at night, or that woman has to sleep at night. You are the person that's all over the place, not the doctors. Please don't get an attitude with the doctor. I want you to go get some therapy, and I need you to line up what you want to do with your life. And I need you to understand that children are very much important. And it is not something that you just go decide you're going to have it with this person, or you're going to have it with this person, you're going to have it with this person. Know that person. No, you pissed me off, I'm back over here. No, you pissed me off, I'm over here. Because this is what you don't understand. Once the baby is made, the baby is made. See, whenever a baby is made, The parents may not get along at all, but the baby is made. It's there. So you have to deal with that. A doctor don't get a choice once they know that you just have a crappy baby daddy or crappy baby mama. Y'all just have to kind of deal with it together, right? But this doctor has a choice whether or not he or she feels comfortable bringing a child into what may be a crazy situation. And so that's what happens when you start to make man a scientist, and he kind of takes the place of the Lord in some types of ways. And I understand there are people who cannot have children, and so artificial insemination is something beautiful. But what I'm saying is, that's when we create things like that, then you create a way for a barrier. Someone can tell you no, and then what do you do? So that's the situation that you're in. And I would say, I mean, maybe you can find another doctor. Maybe you can get everything sent over to the next doctor. But I don't know why the next doctor wouldn't feel the same way the first doctor has felt. And I don't know whether or not that would not or would be in your medical records. I would assume that that's been documented at this point. So, I mean, I don't know. You understand what I'm saying? And I don't know whether or not you can sue this doctor. But I know that no matter what you do, I'm pretty sure the doctor is going to be able to say that they couldn't in good conscience do this because you kept going back and forth. And they just don't feel comfortable and they would like someone else to do it. I think that you cannot get mad at the doctor for not wanting to do that. Not wanting to move forward with you because you're all over the place. Just like an attorney, we don't have to be stuck to a client. We can withdraw. We can get off the case. We can drop the case if it's too much, you know. And he's not dropping you. He's just saying, I don't think that these are the proper specimen to use, or here it's not normal the way you're acting about it, so they're not going to move forward. So I would just say, I don't know what to tell you, child. But I'm not going to tell you whether you should sue a doctor or not. I'm with the doctor on that. I'm sorry. I am with the doctor on that. Next case. Number 3. You want A, you want B, now you want A, but I say C. C, the one you do not know. I think that's better for you. I think that doctor is smart. Let's go on to someone else. All right. I signed a decree and Texas divorce attorney has now submitted to the judge for signature and has changed my verbiage. What can I do? In the final hearing, the judge ruled on specifics as of which were reflected accurately in the final decree submitted to me by what? Baby, you just trying to say too much. And all you have to do is just spit it out. Anyways, let me try to finish. However, her attorney did not submit to judge for final signature. Instead, he filed a motion to sign or enter the decree. I was very confused. It seems his motion is to suggest I was uncooperative. You just signed it. I have discovered why he did this. The motion to enter had the divorce decree attached to the file I was served. I noticed several omissions and changes in verbiage in the new decree. This was a different document than what I signed. The changes he has made significantly benefit my wife. These are afterthoughts that I came up with and are trying to sneak in there under the guise of me being uncooperative. I have the email he sent with the original decree, and I have the email that I returned the signed decree to him within a week's time. He sat on it, then filed this motion. This is very unethical, and I'm wondering what recourse I can take. Is a motion for sanctions appropriate? What he has changed after the fact is blatantly in her favor and manipulates the judge's ruling. Sir or ma'am? Y'all, why don't y'all get attorneys? This is the first thing I want to have a powwow. You know, we're back. You know, Happy New Year. Why in the hell do you all allow the other side to have an attorney and you go pro se and you get mad and say the attorney did shit? First of all, I don't even think the attorney is always doing stuff. I think you're a common person. You're a lay person. You don't have a legal degree. And so you don't really technically understand a lot of the verbiage or what happened. I'm not going to err on the side of, things and say that you're correct. I'm going to say you should have had an attorney. But if you don't get an attorney, guys, which a lot of you guys tend not to want to do for whatever reason, if you're not going to get an attorney, guys, this is what you need to do. What you all need to do is you have got to appear at order entry. The court is going to set the case for entry. You need to show up and you need to tell the judge why you don't agree with the order. You need to tell the judge why you think the order is wrong. You need to file this in some sort of motion and correspondence before the court, before the entry date. And you need to appear at every entry and every court date. And you need to tell the judge why. You need to have a real reason and let the judge tell you that is a good reason or no, it's not. but you have to get before the judge. So when they file this motion to enter, it has a date. Motion to enter the decree, and it's given a court date. The motion to enter is given a date. You need to appear, and you need to say everything that you're saying right now to the judge, okay? And let the judge decide. You're requesting sanctions, but you may or may not be wrong. You may be wrong, and this attorney may have had to put that verbiage because it may be Texas Family Code verbiage. I don't know. Because I know a lot of the times, and this is what irritates me when people don't get lawyers, they call me and they object to language that's in the decree that has to be there by law. Every time when I fail, they come for the all caps. And I say that because there are certain parts in a decree, bloop, in a decree that you have to have in there by law. Child support orders as well. It's in all caps. And they will always come to me and say, I don't agree with this verbiage. And I'm like, I don't really give a shit. Go talk to your Texas state legislature. Okay? They are the ones who made the Texas Family Code, and that is why it's in there. And whenever I say that, they look at me crazy, like, I don't like the verbiage. Well, you cannot argue with me on verbiage that you cannot argue with me on, because I didn't create the verbiage. The legislature did. So go talk to Abbott and them. Go over there and go tell Abbott and them that you don't like the Texas Family Code and that you want it out. Because I'm not going to agree to take something out that's going to make the divorce decree a decree. So I don't know, sir. I have my own dealings with pro se individuals. They don't like to follow the rules of the court. Not because they don't like to follow rules, but because they don't understand. They get very mad at the other side because, they don't have no attorney. So they don't understand. They get pissed off at the attorney. They fight the attorney, and half the time the attorney ain't even wrong. The attorney be right. But then you have attorneys out there that do try to get over on pro se litigants and will try to swap an order. So I don't know which one it is. I don't know if they're trying to swap the order or if you are being difficult. I will tell you that it's not that you're being difficult. The reason they filed a motion to enter. They filed a motion to enter because they need the decree entered and it doesn't have all signatures. So anytime you don't have an agreed order, you got to move to enter it. And the only way you can move to enter it is to file a motion to enter unless you have a hearing date already. So it's not to say you're being uncooperative. It's just for them to say, look, we don't have a signed order. And before you dismiss the case, judge, enter the order. Show up at the hearing dates and plead to the judge. Tell the judge all this stuff that you want to say about the attorney. But dear, in the future, just get a lawyer. I understand people don't have money. I get it, but y'all be having money for attorneys. Y'all are full of it. Like, I'm just going to speak to you in my regular street voice. Y'all be having the funds because y'all will put it on whatever you want to put it on, but an attorney is not something you want to waste money on, so you refuse to do it, and then you want to argue with the attorney about blatant stuff that is supposed to be in the decree, and half the time you're wrong. Sometimes y'all are right, but most of the time you are wrong. So I don't know, because you could be right. You could be right. And then you also need to get an attorney. I mean, and I always tell people this too. If you don't want to get an attorney for the divorce, hire an attorney to look over the order. They'll charge you an hourly fee to look it over and tell you what's in there. Give them the judge's rendition, or they can pull the judge's rendition. Look at it based on the decree. Pay an attorney at least to go over the order with you. Do that. You can do that, can't you, sir? But no matter what you do, please appear at order entry, else that order will be entered against your objection. You can file whatever you want for sanctions, but if it ain't before the court, it ain't before the court. That decree is before the court. If it gets signed first, you out of there. Your sanctions ain't gonna matter because they gonna fall on deaf ears because the case gonna be closed, because there ain't gonna be no sanctions on no parties because the case gonna be closed because the order is gonna be entered. Okay? So listen, follow the rules, sir. Follow the rules of the court. Y'all want to represent yourselves, you got to learn how to be an attorney. You got to follow the rules. You're going to need the same rules of civil procedure everybody else is under. That's the way it goes. But just be in court and tell the judge, honey. That's all I can tell you. We're going to move on to our last case. I know I miss y'all too, but I got a little bit of work I need to do. But let's find a child custody question, because I'm just, the family laws, it's going crazy. So everything's running rampant right now. They in the courts here, they in the courts over there, they fighting over the kids here, the dog there. So let's just hit for a child custody question. All right. I don't know all my rights. I feel like I have been violated and talked down upon from CPS and their lawyers. Girl, join the club, girl. They talk down on me too when I be representing my clients. Is what they do. Next case. I'm just playing. We gonna read it. But that's what they do. Anyways, they are claiming I'm unaware of what is being said and that I've lost touch with reality. I have no idea what's happening or taking place. This hurts me. I need legal advice. I know there has to be a way to get my rights back. It was not fair. It was unlawful to me. So please help me with this. It's important to me. My children, I'm worried about them and me. I don't like the way this is going. That's what it is. You don't like the way this is going. I told somebody last week, when y'all don't like the way stuff's going, you play crazy. I just want my children returned to me. I know, but it's too late. The CPS and the police took them and didn't look back, and they are traumatized because of what CPS did or because of what you did or both. Okay. And I haven't even got a chance to be with my children because of CPS and CASA. Baby, if CASA is involved, you can forget it. Not because they're not fair, but because, baby, they have given you a chance and you probably have failed at that chance. And CASA is like, no. My children and I have a bond, and these people obviously believe they've harmed our bond, but I don't think they are harming. And it alarms me, and it worries me, and it hurts me. And I'm worried for my children since CPS said they won't let me see them or talk to them. It isn't a criminal case. The CPS is calling it a mental case. I have SSD, ma'am or sir. I'm not even going to answer this because I don't know how there's a way I can address this without looking crazy to people or rude or what have you. I'm going to say this. Many times we don't like what's going on. And I have to have this conversation with my clients as well. I've had to suggest for clients that they get mental assistance. I'm not a mental health professional. I'm just bringing you in the court of my public opinion, sir or ma'am from San Antonio, and you sounded crazy to me. And so what I would suggest, if I was your lawyer, and even if I wasn't, I would suggest that you get the help from a mental health professional. Because a lot of the times we're in shock because of what happens to us. We're in shock because of the things that have taken place, and it causes us to have a very absolutely unrealistic thought process and outlook on what's happening. And there's no way that you can ever, I'm not going to say for you to get your kids back, because once you've been terminated, that's pretty much where that is. But your children need you to be happy, whole, and healthy. And they need you to be happy, whole, and healthy for many reasons. If you're already terminated, like you said, you and the children have a bond. And I don't know how old these children are, but I assume when they get 18, they'll be making their way back to you. And that's generally what happens with children that are taking a CPS. When they're old enough to learn, strike that. When they're removed from their families and they're old enough to know who people are, they're old enough to have social media sites and be able to email, there is no breaking the bond between a child and his mother. And I agree with you there. So I understand that although you can't talk to the children or the child, there's eventually a time they're going to come look for you, or they're going to reach out to you or something like that. And ma'am, regardless of whether CPS is not letting you talk to them or not, it's not going to be good for you not to be in a good mental place when they do reach out to you, or when these children do turn 18, because they're going to want answers at that point that they're going to be requesting from you more than likely. You need to be in a good head place to be able to give them the answers to those questions when those children turn 18. There are some children, and I'm not saying this will happen with your child, but when they get in CPS hands, they end up running or leaving CPS at 17, and they go back to their parents or they go look for them. And if the child shows up at your door, you'll put that child in the very same situation he or she was just in, and then you'll also be in trouble because you're acting crazy or not able to address the situation in a proper manner. I don't know how to tell you this, but honestly, when your child is taken, as I said before, there is really no getting your child back. Once that gavel bangs on a termination suit, that's pretty much what it is. Your rights have been terminated. I'm not saying that you should never file for conservatorship again, or that you shouldn't try to get your children back by filing a petition or anything of that nature, because nothing stops you from filing a petition to get them back. And whether or not that would be granted, I'm not going to speak on that. But I'm going to tell you that it doesn't do you any justice. And I tell my clients this because sometimes children are taken away every now and then. I hate when it happens, but sometimes it happens. And when a child is taken away, it's really, I know it's nothing that someone could tell you, because they're not going through this. They're not experiencing this with you. You're going through this, and it's just a really effed up feeling. But you got to get beyond that. Because just like you said, the bond between you and your children will never be broken. Those children will become a team, and those children will come. And you have got to be ready. So I would think that in this time, that you're spending being upset with the situation, I want you to take that time. This is just me to you personally, on a personal level. I want you to take that time working on your mental health. I understand you're getting SSD. I want you to take the time to work on your mental health. And I want you to be in a much better position whenever those children come and find you, whenever that may be. Because I don't doubt that they will come and find you. Okay? You don't want them to find you in shambles. Remember what got you to CPS and what got you in court with CPS, and try to refrain away from that. And when they come and find you, be able to, with a whole heart, communicate with those children. Be able to, with the whole heart, apologize to those children for even having them in the situation or realm to be placed with CPS on a permanent basis. Place of blame is not going to have you where you need to be mentally. Soul searching may mess you up too. But soul searching is going to get you where you need to be much quicker than place of blame. But the only way that you can get there to make yourself better is if you accept what's going on. And acceptance is hard. And it is specific. It especially can be specifically for those who have mental health issues like yourself. But you need to work on that. Those children deserve that. And that's what I want. That's just for me to you. I'm not here to judge you. I'm not here to beat up on you. I want you to know that CPS talks crap to everybody, me included. I talk crap back. It's not because it's you and they're pinpointing you. They're just frustrated. They're in a system where they see a lot of things happen to a lot of kids, and they don't want to have to take a child from a parent permanently most of the time. They actually get upset when they can't give the child back or find somewhere for that child to go. So out of frustration, they may say some things to you. They may not be necessarily lying to you by telling you, things. They may hurt your feelings telling you that you're not in reality. But you have to understand, you're also talking to the side that is trying to take or has taken your children. And you are sounding completely irrational to them. And they're going to use that against you in court because they have to. So be very careful speaking to them openly when you know that you have a problem. And then I want to say this. You're in the state of Texas. Anytime they move to terminate your rights, they appoint you an attorney. Why are you seeking my advice and have not sought the advice of the attorney that they gave you? A lot of the times, people get appointed attorneys, and just out the gate, they don't want to trust them. You're not working for me, you're not doing this, you're not doing that. But it goes down to you not liking to hear things that you don't like. You don't like it, and so you don't want to hear it. And so whoever is the vessel that's giving you that information is the person that you blame or the person that you jump all over. That very well may be your attorney. And when you have an attorney there to fight for you, you need to be open and honest with your attorney and wholeheartedly let them know what you can so that they can assist you. And I tell my clients this as well. Be open and upfront and honest with me. If you can't be open and upfront and honest with your damn self, please. Some stuff you will have told to me that you will have heard for the first time ever. And that's because a lot of the times we don't like to be serious. Or not serious, but honest with ourselves, right? I've had clients say, damn, it's the first time I heard that. And I know exactly what they mean. Because they've been lying to themselves all this time. But when I'm talking to them, I'm begging them to tell me the truth, the whole truth and nothing but the truth, so that I'm able to assist them in the best way possible, whether it be good or bad, because I'm not here to judge them. That's not what I'm here to do. I'm here to win their case. I'm here to put them in a good position. And I can only do that with truth. And I can't tell anybody when they tell me the truth. I'm not allowed to do that. That's illegal. That's against what I've signed up to do. I can get in trouble for that. So tell your attorney. Your attorney can't go against you. They can't tell people what you say. That's illegal. You know, you can admit to your attorney things, and they can give you their honest response. And they can tell you the best way that they can help you. But if you're not being serious and honest with yourself, baby, you're up against a losing battle, especially in court. I don't care if it's a criminal, a family, a car wreck, any sort of case, custody. Um, when you're not being honest with yourself, it's a losing battle. You almost just go get the other side. Just give them what they want. Bloom, hand it to them. Because when you're not being honest with yourself, your attorney can't fight for you. So, I wish that you had a better relationship with your attorney, but that starts with you being able to accept that which that you do not want to hear. And a lot of the times, an attorney is the vessel that is telling us things we don't want to hear. So we are in a very bad situation because we don't want to talk to our attorneys. But you're coming to talk to me. But that attorney knows you better than I. And they probably lined up and knew better how to help you than I could ever know. So, mental health, you're going to focus on that. Because if you have been termed, you have been termed. But your mental health is something that will always pull you through. You don't want to have any other children taken. And once they terminate, most of the time, if you have any other children, CPS will take those children from you as soon as you have that child at the hospital. So you need to also keep that in mind. If they have not terminated you yet, you still got a way to fight. Mental health is going to be the first thing, though. Okay? With that being said, I am going to wrap up and close the court of my public opinion. Okay? We are going to stand in recess, honey, until we meet again. Until the doors open. Until the next show. So y'all already know. Like, subscribe. Also hit the notification button so that you can know every time I upload something. It's good to see you guys. I haven't seen you in a minute. Thank you for watching my channel. Okay? Oh, and always email me, booker@bookerlawfirm.com, if you want your question to appear on the show. Make sure in the subject heading you put YouTube show so that I know that this is like something separate from one of my office emails, okay? Because I don't want to just forward you straight to the administrators or something, because that's what I'll do if I don't realize that it's a show question. Have a fantastic day. Bye. I miss y'all so bad. Bye.